Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-5069. Fleta Christina Sabra, appellant versus United States Customs and Border Protection. Mr. Fels for the appellant, Mr. Walker for the appellee.
Morning.
Good morning. May it please the court. My name is Andrew Fels, and I represent the appellant Kalila Sabra against the appellee agency CBP. As I will address, there has been no adequate search of CBP's records in the past 7 years. The best illustration of this point is comparing the declaration on page 138 with the CBP policy that is now in the record and looking at the mismatch between those. In theory, for a routine search of civil rights investigation records like this search, it should be a simple matter of going through the relevant policy and matching the agency declaration with that policy. We don't have that here. And the declaration itself is, I think, inadequate in part because it does not address internal affairs to begin with. It only describes the search of 5 employees' emails.
Step back a little bit and
Yes.
say specifically what language in the policy you're referring to when you say that the match is not comparable.
Yes, Your Honor. Let's see. The major points here are in the policy. You've got, let's see, 8.2, 8.3, CRCL communications with the CBP commissioner and deputy commissioner. That's one of the primary communications that is not here. It is missing, and there's been no search for those records according to the declaration. And that seems to be key. Certainly the McAleenan, the deputy commissioner email that was introduced in the response to the second motion for summary judgment indicates that there is in fact an ongoing conversation between CRCL and the commissioner.
Okay. I'm sorry. And what I would say is you would agree that it doesn't have to match specifically your FOIA request, right?
That the
That any search would not have to match a specific FOIA request.
no, it would not have
You
to
agree with
match.
that?
Yes.
And then it doesn't have to be specific terms as to what you as a complainant are requesting.
Yes,
Okay.
that's
And
correct.
so in here, I feel like there's 2 areas that would be of concern to you. One is not having the use of your client's full name as opposed to breaking it up into parts by saying Sabra and then saying 2 other portions of her name. But you felt like the full name should be there.
Yes, Your Honor.
And then I'll ask the other side about the technology as to whether or not that search term would have on its own gotten to the full name just by putting in Sabra at least, okay? So that's one area. And then as to the McAleen email, I think where you're headed on that is that you asked specifically for searches with respect to the encounter and the investigation, and you believe that the investigation was not searched because they only dealt with witnesses, not people who were actually involved in the investigation, and that the McAleen email would have led you there.
Yes, Your Honor. It's hard to speak to the factual, some of the factual underpinnings here, and certainly the agency is afforded a presumption that it follows its own policy. And so under Biological Diversity Center, it seems like it would have gone through all of those steps in its policy if and hence that we could have expected all of those records to be made available. And one of the key areas of the motion for summary judgment, of course, is the existence of the Office of Internal Affairs. The McAleenan email discusses at some length does not discuss at some length, but there are email addresses there that are linked to or referenced to the Office of Internal Affairs, IA. And under the policy, it's the Office of Internal Affairs that is doing all of the investigative work.
Isn't that just I mean, isn't that argument just formalistic? I mean, there was an Office of Internal Affairs. It's been renamed the Office of Professional Responsibility, and the agency made clear that it searched those records. Whatever the office is called, you know, the agency states that it searched the records of that office. So the fact that the name change doesn't seem to suggest that the agency's search was unreasonable, which is, after all, the overall standard.
I think to answer in two parts. One is there is the question of when was it renamed to begin with? And also, if under 552A2, the agency is required to make public all of its policies, in part because, you know, as this case touches on, people are filing FOIA requests for those records. Here, the public policy says it's the Office of Internal Affairs that is doing this investigation. And now we've got...
Isn't that public information, though, about the name change?
It's not within the policy itself.
But I'm talking about the renaming of it is public information, renaming of the agency. I just feel like you're kind of splitting hairs in that regard, along with Judge Rao's question.
And it may be that ultimately that these are exactly the same offices. But again, going back to the idea of the agency must make all of its policies public. If you've renamed the body that is investigating your civil rights complaints, and CBP being the largest law enforcement body in the United States, that's critical. It does seem important that your policies reflect who is in fact in charge of this, because we get into some debate here regarding whether or not and to what extent this should have been referred to CRCL or OIG. As written, if I go on the website and I look up and see who is supposed to have done my investigation, currently it's the Office of Internal Affairs.
But you're not making an allegation that they didn't, in fact, search the correct office. You're just saying that the policy uses the name of the old office. So again, I'm not sure how that says anything about the reasonableness of the agency's search.
Well, and even if that is the same, that these are exactly the same offices and they conduct exactly the same kinds of searches, that still leaves us with the question of the whether it would have been reasonable to search for CRCL communications with the commissioner of CBP. And that's one thing that does not seem to have changed. And we've not, the declaration certainly does not address why this was reasonable to not search those emails, or not search for those communications. It simply says that we searched the 5 emails of these particular CBP employees.
To me, that's a different question. The agency, even in turning names, changing over to a different name, they produce those documents and they indicate so about the name change. But if you're asking about the emails, that's what I was going to earlier. That goes to a difference in only searching witnesses versus searching anybody involved in the investigation, which did not necessarily be limited to those 5 witnesses.
Yes, Your Honor. And yes, I believe she was originally seeking.
And is there anything that you've been made aware of that suggests that something will turn up if that search was different?
I believe the McAleenan email itself is indicative of the fact that the agency was in fact following its own policy in this regard, and that there would have been that follow-up communication. And certainly that does seem to be the presumption that it would have been following its own policy.
We'll just see if my colleagues have any further questions.
Just, you also mentioned the incident case number. Why do you believe that's relevant to be part of the search?
The incident case number, and it's certainly not clear to me from this perspective, to what extent that is used, say, as an email header or something that is used in the body of communications to discuss a particular event, to say, this is about case number ... As opposed to saying this is about Khalil Sabra or whichever name is being used.
And then you also indicated that they should have asked other component agencies or either sent these same requests to other agencies that might have been related in some regard.
Yes, Your Honor.
Did you FOIA other agencies?
I was not the trial counsel.
Or trial counsel?
I don't think so. I don't know if he would have.
But that could have been done separately.
It could have been. It appears that this policy was not released until 2020. So it's unclear how anyone would have known how CBP conducted its investigations until that time.
But I'm saying when you say, when I asked him the question about FOIA other agencies, anybody meaning you, your client, your entity, represented to specifically query those agencies separate and apart from CBP?
I think here, no, I don't think they did that. And I think in part because CBP relies in large part on CRCL, which is a different part of the DHS, to do a lot of its investigative work according to its policy. And, in 2017, I'm not sure how they would have known that. The policy existed, but as in the reading room, it's listed as being posted in 2020. So this would have been 3 years later.
Thank you. We'll give you a few minutes on rebuttal.
Good morning, Your Honors. May it please the Court. Johnny Walker on behalf of U.S. Customs and Border Protection. I want to start by addressing the policy because my friend has made much of the case on appeal about that policy. As a procedural matter, that policy was never brought up in the district court. Now, the posting on the reading room that he cites in his brief was posted in it was posted in 2020, February of 2020, 1 month before this complaint was filed and 1 year before the parties briefed summary judgment. So that policy was available to the plaintiff at the time they made their summary judgment arguments in the district court, but it was never raised in the district court where we could have built a record about it. But the policy on its face does not implicate the creation of any additional emails or any additional investigations other than what's been provided. They rely on these sections, I think it's at 8.2 and 8.3. Those are provisions that have to do with situations where the Department of Homeland Security's Office of Civil Rights and Civil Liberties makes recommendations for corrective action following a report. There were no recommendations for corrective action made in this instance, and so it's unsurprising that there would be any, not be any additional emails involving Mr. McAleenan, the Office of Diversity and Civil Rights at CBP, or the Office of the Commissioner of CBP.
So I want to go along the line of some of the questioning that I had to your colleague. There's been an intervening case, American Oversight. You familiar with it?
I'm familiar with a few American Oversight cases.
Okay. Well, this particular one holds that an agency affidavit must provide a detailed explanation of an agency's failure to use obvious alternative search terms. So I want to start with the name, because you did not use the entire name in the search mechanism. Is there a reason for that? Because I just don't know if that would have gotten some different information.
It would not have, Your Honor. So if they used, she has a 4-part name ending in Sabra, right? So if her 4-part name with spaces in between appeared in a document, simply searching that term Sabra would find any instance where her full name appeared. And just to be overly cautious and ensure that its search was complete, her last 2 names are cousin Sabra. Those generally appear on the documents with a space in between, but just to capture any document where they may happen to not appear with a space in between, the agency also searched with them without a space in between and with a hyphen in between. So they cast a very wide net here. In addition to her name, They also searched terms associated with the individuals with whom she was traveling and assisting to apply for asylum. So they searched the terms Syria, Syrians, and Syrian, and that returned, I think, something like over 13,000 pages of documents. It was an incredibly wide net that they then went through to find any documents that were actually specific to her request.
Okay, and then what about the response time? Because it said you were supposed to do it on the expedited basis for 10 days. It took over a year. So I'm just curious as to whether or not you all ever followed the provision of expedited time.
I know that within a few days of her submission of a FOIA request and request for expedited processing, there was an acknowledgement sent to her that informed her that her request was being placed on the simple track, not an expedited processing track. But I think our more general point there is that once the agency produces all of the records, the question then becomes whether or not that the redactions are adequate, whether the search is adequate. Here, the only issue, of course, is whether the search was adequate, and the timing of the agency's request becomes moot. I think this court recognized that in the Payne Enterprises case, or said as a general and individual FOIA request, once the releases are complete, the question of timing becomes moot. There's an exception for policy or practice claims, but that's not a claim that the plaintiff has presented here.
And then with respect to the investigations or deputy CBP commissioner's involvement, how do you all get beyond only that email being produced when they specifically asked about investigations, not just the border issue?
So I think there's two separate questions there. One is whether or not the policy indicates that Mr. McAleenan would have had any additional records. And then there's the separate question whether the one email that was produced indicates whether Mr. McAleenan would have any additional records. I think I've addressed the policy. That he would only be involved if there were findings and recommendations. There weren't here. With respect to the one individual email, the question becomes whether or not that email provides a clear and certain lead that there are other documents available. And our position is that it does not. It's an email forwarded from the Office of Civil Rights and Civil Liberties that simply informs Deputy Commissioner McAleenan that this complaint has come in. It doesn't indicate that he is going to be kept further apprised of the investigation of that complaint or that he would have any further involvement in the investigation of that complaint. It's a purely one-time informational email, so it does not present a clear and certain
But
lead.
do you not see a distinction between witnesses versus who is part of the investigation? Because witnesses seems to focus on what happened at the border versus who then receives the internal investigation and then their involvement.
I see the distinction. I think the only argument that plaintiff has made in this case is that it was Mr. McAleenan who would have been involved in additional investigations. And I don't think there's any need to conduct further investigations of him because there's no indication that he would be further involved in the investigation. The distinction between, so I think you have to go back to the language of the FOIA request. The FOIA request specifically requested documents about the encounter itself between Ms. Sabra and the 5 CBP agents. And I think it was reasonable to search the way CBP did, which was to identify every agent with whom she encountered and every agent that witnessed that encounter, and to conduct an expansive search of their emails using expansive search terms over the course of 6 months, which would have included the time immediately following the encounter, would have encompassed the time during which the investigation was conducted. And then CBP also searched a number of different databases where it knew information about that encounter may be stored. That includes the SIGMA database, where they record records about encounters at border crossings and detentions. It includes I think it's the E-STAR database, which includes any records about uses of force. It includes the Joint Integrity Case Management System, where they have stored any records about investigations because they knew an investigation had been conducted. And it included the Chief Counsel Tracking System, which is where they store any sort of legal documents.
And then the other thing that I would ask is, when you all put your searches out there, you seem to have used different terms at different agencies. Like, in other words, there wasn't one blanket search and then it went to all the agencies. Why is that?
I think there is largely consistency between. The only sort of distinction that I know of is that many of the agencies searched Ms. Sabra's name, whereas the email search was both Ms. Sabra's name and sort of the Syrian variations. And I think that's just sort of the minor differences there, just sort of a product of each sort of office being tasked separately to conduct a search in the way that it knows will best find records within its particular databases and systems. So a lot of these offices are searching a particular system, the sort of various systems that I just went through. And so they sort of know how to pull a record from within that system. It's not sort of an email search like the Information Technology Office did. They're sort of trying to target a particular record. And as you can see, they were successful in doing so with the exception of the use of force records because there's what simply wasn't such a record. There's one other thing I'd like to address, which is this distinction between the Office of Professional Responsibility and the Office of Internal Affairs. I think I can simplify that issue even further. I think the issue is not so much who is the office that is performing the search, but where are they searching? And what our declaration at JA 141 to 42 describes is that the database, the repository where CBP stores its investigatory records, is the Joint Integrity Case Management System. So whether it's the Office of Internal Affairs that's in existence right now or the Office of Professional Responsibility that's in existence right now, the location of the record is going to be the Joint Integrity Case Management System. That is the repository that was searched, and that is the repository where they located the documents about the report.
And do you feel like the affidavit sufficiently explains why you did or did not choose certain search terms? And is that something that the law requires?
I don't think the law requires that we submit a declaration sort of addressing each of the search terms that they propose. The agency is ultimately responsible for selecting the search terms.
I do agree with that, but I'm asking about your method for selection. In other words, do you have a duty in your affidavit to describe why you chose your route in terms of the search terms, or why you did not?
I think we certainly need to argue that, but if it's brought into question, I think we've said, that given the content of what she's asking about, which is an encounter with herself while traveling with a group of Syrian nationals applying for asylum, the appropriate search terms are her name, because she's the one who would be involved in the encounter, and the individuals that she was traveling with because they were also involved in the encounter. We've also addressed, as an argumentative basis about that additional search terms would not necessarily be expected to locate any additional efforts. Search that we've performed is incredibly reasonable. As I said, the search of the emails in particular cast a very wide net, pulled in a lot of documents that they went through individually to determine what was responsive.
Beyond just references to witnesses.
I'm sorry?
Beyond just references to witnesses.
That's right. It would have been that when they went through to find what was responsive, meaning they looked for documents that were about her encounter with the CBP agents. If there are no further questions.
Thank you, Mr. Walker.
Thank you. Please affirm.
I'll give you 2 minutes, Mr. Fells.
Thank you, Honor. How do we know that there were no communications with CRCL and the commissioners unless it's in the affidavit? If we've got to rely on the affidavit, it would be in there. There's no search described that would include those records.
Mr. Fells, what about the fact that this issue was not raised below, even though it was an argument that was available during the summary judgment briefings in the district court?
Certainly, it would have been better had it done so. However, what was raised there, the issue was that filed the second motion for summary judgment, and in the response, that included the email between CRCL and the deputy commissioner. In a footnote, that's where CBP responds that no, in fact, like OPR and the Office of Internal Affairs are separate offices. At that point, it's not clear whether there was any need to cite to the policy, because it seemed very clear from that email that yes, there's an Office of Internal Affairs. Yes, there are communications between CRCL and the commissioner. That seems like that should be enough to defeat the motion for summary judgment alone. But then we also get back to the fact of CBP does not mention nor seem to have followed through with what it knows to be its own policy. Why wouldn't this already be in the affidavit? Why wouldn't they just go through and do the search that is based off of their own process? There's no mention of the Diversity and Civil Rights Office either. We don't know anything about that.
Thank you, Mr. Fels. Case is submitted.
Case number 23-1281 et al. VTCU Corp petitioner versus National Labor Relations Board. Mr. Goldberg for the petitioner, Ms. Sheehy for the respondent.
Morning.
Good morning. May it please the court, my name is Andy Goldberg. I'm the lawyer for the appellant VTCU. I've asked for 2 minutes for rebuttal at the end, if I may do so. We are here this morning to ask the court to reverse the National Labor Relations Board finding of an unlawful refusal to bargain and the attendant certification of a bargaining agent in order a rerun election or at least a hearing on the merits of the objections. The board erroneously dismissed challenges to a representation election without a hearing and improperly certified the union as a lawful bargaining representative. So we are asking for either a rerun election or, short of that, a hearing on the objections. We're here before you to argue these following main points. One, that the 3-week election period and the attendant problems that arose from that were too short, that void ballots should not have been counted, and that the threats which were made by union representatives to eligible voters also tainted the election such that it should be overturned.
So as to those first 2 points, I mean, didn't VTCU agree to a 3-week election period and then also agree to count those ballots?
So the problem with the argument about the agreement as the board has put forth is that it fails to recognize the process for entering into a stipulated agreement. That is not a separate and distinct agreement where the parties go aside into a room, come up on their own. That is a board managed process. And at the end of the day, when the parties submit that stipulation, the regional director has the authority to approve or reject that stipulation and find that the parties' recommended process is not proper. And in fact, this region has given 4-week elections in cases with voters who are far fewer in numbers than we have here. And the region is responsible and the board is responsible for ensuring there's an
It's like a very
adequate.
difficult standard, though. I mean, if the parties agree to a 3-week period and they're not really, there are instances of a 4-week election. There are also instances of shorter elections. I mean, the agreement seems to carry some weight. For us to say that the regional director committed some error when the parties agreed to a 3-week period.
But the regional director is ultimately responsible. And so the parties who are not charged with knowledge of the mail issues, with the processes of whether or not that count is going to make it in time, that's all the responsibility of the regional director. And that regional director should have known of the issues in the Pocatello area with the mail. And matter of fact, now when you look at the federal elections, those mail ballot elections are being mailed 45 days in advance, another obviously federal process. And so the regional director should have known, and the regional director should have said, this isn't sufficient amount of time, and we're not going to grant that.
And the regional director should have done that, notwithstanding the parties' agreement.
Yes, because that is the process. The regional director has to approve the STIP. What's the point of having the
It's not
regional?
the typical arrangement. It really does matter in most, and these go on all the time. Typically, when the parties agree, there's nothing facially unlawful about 3 weeks, as opposed to 4. And it would be quite unusual if the regional directors wouldn't have enough time in the year to do what you're asking. The parties agreed, it's facially lawful, the regional director accepts it. That's not unusual, and it's certainly not unlawful.
I'm not suggesting that it's unlawful. I'm suggesting that in this particular case, there was evidence that the regional director should have had and was available to the regional director, that the regional director should have known there should have been a longer period of time. We have the people, the evidence that we submit an offer of proof of those who didn't get ballots. We have the number of people who were eligible to vote versus the number of people who actually voted. So there is not just speculation here. There was actual evidence that there was some issue with the time period allotted, including the
So
one.
you're using what happened after the fact of the agreement to prove that the agreement should not have been accepted. In other words, the regional director should have known that you might assert some problems later on.
No,
This is a facially normal agreement, facially acceptable. There's nothing that would cause a regional director, nothing that's on this record,
so what
to
I'm,
think that there might be issues, and so the parties' agreement was accepted. That's what's typically done.
but what I'm suggesting here is that there was evidence that there were issues with the mail itself, and that those issues, not the after the fact of the approval, but even before that, there were issues with the mailings in Pocatello, and the regional director was responsible for knowing that. The after the fact evidence establishes that that period wasn't appropriate and just supports the argument that the regional director should not have approved it in the first place. So in addition to that, the board has suggested that we're not entitled to argue that if we don't get a rerun election, we should also have a hearing because we didn't raise it in the objections and the request for review, which is not entirely accurate. We didn't specifically state that for sure, but we did generally say we'd like the decision overturned. And a hearing is a remedy. And the remedy when you overturn a decision is one of two things. It is either you get a hearing or you get a rerun election. And in this case, the board is asking to have the court just accept that its conclusions of law here are valid and appropriate, and asking the court to completely defer to their standard, which is really an interpretation of the law and not just a finding of fact, because there were no findings of fact here. There
Don't
was
you
no.
understand what you just said? We're hearing you say, it's true, we didn't specifically raise it, but the board sort of surmised that's what we would have liked if they had thought about it carefully. You have to raise an objection and indicate what it is you're precisely objecting to and what it is you think you're entitled. You didn't ask for a hearing, you forfeited.
Well, but a hearing is not an objection. A hearing is a remedy. And so we shouldn't have
You've got to
to.
raise your request for whatever relief you think you're entitled to. You didn't raise it. It was forfeited because the board is there and they can't respond to that request. If you don't raise it, you didn't raise it. And now you're saying to us, well, they should have understood. That's what we really would have liked to have.
Well,
When it's not routinely done.
well, if there is a remedy, if
It's
there
not,
is.
counsel, the board followed procedures that they follow all the time, every day. They didn't do anything here that was untoward. It's the way they operate. And so if you didn't specifically say to them, no, in this case, you should not follow the norm, you should give us a hearing. You didn't raise it. You didn't put them on notice that that was an issue.
Well, I think they were on notice because we asked for the objections, the denial of the objections to be overturned. And so that puts it then in their hands to give us a remedy, which includes a hearing or a rerun election.
Well, it seems that a lot of your objections are either waived, as indicated by Judge Edwards, or there's a jurisdictional bar because they were not exhausted by being specifically acknowledged, and you appeal to that relief to the board even before you come through this process.
Well, the only argument on that particular one is the hearing as opposed to the rerun election, because we did specifically request a rerun election in our filings, in all throughout our filings.
But I guess what I'm saying is you have a lot of objections. Some of them were either not raised at all to the board, or they were not raised to the court.
And the reason for that is because as time goes by and you learn what you're then truly going to be able to establish, you're going to focus on those objections where you can, in good faith, bring forth facts. And some of the evidence that has come up later, we have chosen to rely on those objections where we have a good faith belief that we can present evidence in support of this.
Mr. Goldberg, I was wondering, the regional director used a standard for reviewing alleged, election misconduct. They used the reasonable doubt standard. And in your brief, you talk about a different standard that we use in a different line of cases about disenfranchisement. And I'm wondering if you think the choice of a test makes a difference in this case.
We do, because there are voters here who were disenfranchised. And we believe that those are the standards that should be used, because people did not receive a ballot. Other people didn't cast a vote. One person's vote came in late. And so when you're looking at disenfranchisement of the voters, that is really what we are arguing here with respect to the 3-week time period and those individuals who didn't get a ballot and the one whose ballot came in late.
But is that disenfranchisement standard different than asking whether there's reasonable doubt about the fairness of an election?
So there's lots of different ways standards of review have been phrased in the various cases that come before, with substantial evidence, with deference, and what have you. At the end of the day, the question is, was this a properly conducted election such that the voters had the reasonable opportunity to vote in a time period that was effective for that election? And our position is the time period was not.
And even if we thought that it wasn't reasonable, are you able to show prejudice here?
Prejudice in terms of the voters?
Right, in terms of the outcome being different.
Well, I think yes, because we have the 15, now as it comes clear, the 15 voters who in fact did not receive a ballot, the one that came late, and plus, again, those 5 void ballots, plus the threats against the 3 other individuals, plus the cases have said that when there's evidence of impropriety, or in this case, the election period not being sufficient and voters impacted, you can make the conclusion that others were impacted as well. And so that's, again, part of our argument based on the number of people who voted and those who did not.
But if I look at that, I'm not sure that I come to you with the same math on this being outcome determinative, because the vote tally was 66 in favor of the union, 45 in favor of the employee. Add back your 5 challenge ballots, get you to 50. Add back those 15 others, that still gets you to
20.
65.
Yeah. And then
so you still lose by 1.
And then the 1 late ballot. And then the 3 people who, or the 2 people who were threatened.
So you have to win on all of those counts to
Yes.
demonstrate prejudice.
But what wasn't the one that you're referring to untimely though?
The late ballot,
Yes.
and we're saying because of the 3-week election period.
Okay, but then going back to Judge Rao's question, you'd have to win on that first to get to that other one.
Yes, Your Honor.
Thank you. We'll give you a few minutes on that.
Thank you.
Please the court, Barbara Sheehy for the National Labor Relations Board. I'm going to start where opposing counsel finished, sort of Judge Rao's question about the standard of review, or the standard that was used here. And Your Honor is absolutely correct. The board used the reasonable doubt standard. But I want to clarify a couple of things I think that are sort of surrounding that issue in the case. It's never been raised that was the wrong standard. So I sort of want to start there. There's been no challenge that the board used the wrong one. There are other tests out there, as opposing counsels correctly articulated to the court. So it's never been.
Could you at least give them credit that if they believe that the other standard was applicable, that by inference, they believe your standard was incorrect?
So here's the problem with that. So I think if they had clearly said that, or it was reasonably discernible from their request for review, because that's their opportunity to tell the region, that's the opportunity, sorry, to tell the board, hey, we think the region got this wrong. So the region very clearly articulated the reasonable doubt test. Very clearly, it's in the applicable standard or applicable legal principles. So there's no question what the region did. Then you look at what did the employer file in its request for review. And so what you're asking there is the board, you're trying to tell the board, we think you need to review and dig deeper into this case because here's what the region did wrong. And in that request for review, the only thing they say is the employer cites to National Hot Rod, which is a case out of this court, and then it cites to 3 other cases cited in National Hot Rod. But they don't say, they never say you applied the wrong standard. They articulate a standard that's in National Hot Rod. And then, like I said, they cite to 3 other cases. Here's the problem with that though. The 3 other cases and National Hot Rod itself actually don't get into what is the appropriate standard. Is it reasonable good? Is it reasonable doubt? Is it the possibility of disenfranchisement? What the issues were in those cases was the misconduct by the board? Was the misconduct by the employer? Or was the misconduct a responsibility of the parties? Those were what were litigated in those cases. So National Hot Rod had to do with who was at fault for this one employee in a 1-vote determinative election, who was responsible, more responsible, I guess, for this employee not being able to vote. The board said, we think it was the employee. This court disagreed and said, no, we think it was the board. In the other 2 cases, one of them visiting nurses had to do with an employee who showed up late. And these are the only cases cited in their request for review. So without telling the board what we think you did wrong, the board is reasonably looking at, okay, you say we're inconsistent with our precedent. Let's look at what it was. Visiting nurses had to do with an employee who showed up 15 minutes before the ballot, or before the vote was to close. So it's a manual ballot. Shows up 15 minutes late. As on arrival, she gets a text or email or something from her supervisor. She goes to talk to her supervisor. She sort of gets way late again before she actually makes it to the ballot, to the voting, and she shows up late. The board said, we don't think that was, so there was an allegation there, an objection. Who was at fault there for her not getting there? Was it the employer interfering with her in her last 15 minutes to get there? Or was she more at fault because she had plenty of time, according to the board, they found there, she had plenty of time after she spoke to her supervisor and still getting to the ballot. She could have voted. So the question in that case was who's at fault? And then I can't remember.
Ms. Sheehy, what's the connection here?
So the connection is, so this all to say, if the employer doesn't tell the board that it applied the wrong standard. So we are dealing then with the reasonable doubt standard. I would acknowledge that if it had been clearly raised and they had clearly articulated, this standard is wrong, here's what you should have done, then yes, it is the prejudice showing is different in that case. I won't speak to whether the board would have come out in a different way, partly because I think fundamentally.
Is it the board's view that these tests are different, that they would lead to a meaningfully different result, or that they should apply in different contexts? I mean, we do seem to have these 2 lines of cases with different standards.
Sure, and the court has recently addressed this. I'm sure the court is aware in GHG. This is actually discussed. It was a remanded case just 2 months ago. And I think I'm not going to speak for the board because we'll hear from them on remand as to what exactly is the difference between, or what's going to be the dispositive issue on when we apply which tests. So I can't answer whether the board sees a meaningful distinction on what sort of conduct triggers which test or what that distinction will be. I can certainly acknowledge that the prejudice showing is different. One is possibility of disenfranchisement and one is actual showing of disenfranchisement. So beyond that, I'm not comfortable sort of trying to speak for the board because like I said, we should hear from them on remand. So absolutely, there are different tests. We're not saying otherwise. What we're saying is if you know there are different tests, and we all do because there's lots of different cases out there applying several different tests. If you didn't think the board did the right one in this case, tell them. Don't rely on cases that have nothing to do with yours. Don't rely on cases that have nothing to do with the issue here. This didn't have to do with who was at fault in any particular way. Oh, sorry, go ahead.
I had another question.
Sure.
With respect to counting the ballots, the printed ballots, looking at the board's, I guess, like the case handling manual provision, did the board or did the regional director need to find either that the parties agreed that these were signatures, or would the regional director have to find that they were the actual signatures? Because arguably, it's not clear that the regional director did either of those things.
So I think first if we look at what the board did first with this is the board first finds that the 6 ballots where the name is either printed signature or printed were not outcome determinative. So that's sort of the first wave of defense, I think, by the board on those. But getting to your question about what they found. So here, what they did, I think what the regional director did here in this case was that the parties, the ballots were flagged. So they were among a number of ballots actually got flagged as print. And then I think there were 19 total, actually they had print, and then they sent out a bunch, they resent. At the time of the count, there was still 6. So they were set aside. The parties are all in the room at the ballot count. These ballots then come up and the parties agree that there's no question about the identity of the voter. So that's the whole reason for this provision, is the security of the vote. There's no question that the identity of the voters. There was no question that there's actually evidence of different signature by these people, which was the case, for instance, in Longmont in this court. There was some question there. So I think what was found here was that looking at the ballots, the parties agreed that there was no issue with the print signature. So I'm not sure if that answers your question, but I don't know that the regional director has to make the finding first, because the regional director doesn't get involved, is my understanding in the case handling
You're saying
manual.
it wasn't a disputed issue.
It wasn't, right, the parties agree, right. And so again, that goes to, I think, the whole, at the beginning of opposing counsel's argument, we had the issue about the consent to the stipulated election agreement. This is another instance where the employer is trying to back out of agreements it made because it doesn't like, at the end of the day, it didn't like the results of the election. It entered into a stipulated election agreement, setting for the 3 weeks. They had every opportunity to raise apparently these well-known mail issues, never raised them. And then they agreed to count the 6 ballots. So I think unless, I don't have anything else I wanted to, oh, sorry.
Just 3D, if you would go do the math
So what,
in terms of whether it could have been outcome determinative or not.
so which ones do you want?
Well, my math was indicating that even with the 5 challenge ballots, if you add it back in, because you were at 6645, that gets you to the 50, and then there were 15 other ballots that you could count, so you would still be 1 short.
Right, so, and then I guess I didn't understand, I guess, until coming in, I guess today, just now that the 1 late ballot was also part of this. So I don't read their brief to say that. So my position would be that it still is not outcome determinative. They still haven't done it. And I'll be quite honest, I think the math is pretty messy in a lot of parts of their brief. So I get quite confused on what's being argued and what numbers are being used, but I do think it's the board's position. Right, it's 66 to 45, 5 challenge ballots, 15. And I would point out in the offer of proof, it's not, the offer of proof related to the ballots that the employees would have testified that they didn't receive a ballot. The offer of proof actually says more than just that. The offer of proof says they didn't receive a ballot or they received it late. We don't even know what the allegation is of those 15. Was it 1 who received it never or never received it rather, and 14 who received it late? Because that's a different question. So I think fundamentally.
Talking about the people, but they never requested a duplicate ballot.
No, I'm talking about the very first objection, 3B, I think it's 3B.
Yeah, I'm sorry, I said 3D.
Where 3B, where it speaks to, they say 17, it's actually 15 because somebody's double counted and somebody actually did vote. But if you read the objection itself, before you actually get to the numbers of the people, it says never received a ballot, in parens, or received it late. So we don't even understand what that objection is getting to. So fundamentally, this is the last thing I'll say because I see them over time. Fundamentally, I think the board views this as a failure of proof case, and we would ask for full enforcement. Thank you.
Thank you. Mr. Goldberg, we'll give you 2 minutes.
Thank you. So a couple of points that I'd like to talk about. One is the well-known mail issue. So again, the employer was not aware of those mailing issues until after the issues came up in the election itself. So the board has said it's our responsibility to do essentially an analysis so that we knew about it. When we had referenced in our briefs that it was a well-known issue, we meant it was well-known, should have been to the board, not the employer's responsibility to do that investigation because it's the board's obligation to do so. The board has also said that they looked at those void ballots, figured it was not outcome determinative and sort of made their conclusions. We're looking at this as a whole. You need to look at the entire context and figure out all of the numbers of the people that were involved here and not being able to get into it. As to the standard, we have very clearly in our request for review talked about voter disenfranchisement. And that was the number one and first argument that we made in terms of the people not being able to vote. And that was the standard that we had argued and talked about. But again, at the end of the
It
day,
is the standard you argue, but you didn't, it seems to
Explain
me, say that the regional director applied the wrong standard.
no, we did not specifically state that. We stated the standard that we wanted
In an
applied here.
adversarial system, it's on the attorneys to make the arguments they want the board, to put forward issues and arguments for the board to address.
And we set forth the standard that we believe the board should be following by affirmatively asserting that it was a voter disenfranchisement case. The last thing that I would like to, I think actually I did cover all the issues I wanted to talk about. Thank you.
Thank you, Mr. Goldberg. Case is submitted.
Case number 23-7124. Calvert L. Potter et al. Appellants, Tariq A. Ali et al. Versus District of Columbia. Mr. Munch for the appellants, Ms. Grazinari for the appellee.
Whenever you're ready.
Good morning, and may it please the court. I'm Lucas Munch on behalf of plaintiffs Calvert Potter, Steve Chasen, Hassan Umrani, and Jasper Sterling. Plaintiffs are Muslim and Jewish first responders who wear facial hair in accordance with their faiths. After extensive litigation, the district court entered a permanent injunction in 2007 that prohibits their employer, the DC Department of Fire and Emergency Medical Services, from enforcing against them a requirement that they may not have facial hair that comes between the sealing surface of the face piece of their masks and the face. Despite this permanent injunction, in March of 2020, the department enforced against them that precise requirement, ostensibly due to the onset of the COVID-19 pandemic. The department did not petition the district court to modify the permanent injunction, nor did the department consider less restrictive, viable alternatives. They simply disregarded the permanent injunction and plowed ahead.
So we're supposed to look at this as to whether or not that permanent injunction was clear and unambiguous as to facial hair. And in the permanent injunction, it mentions Special Order 20. So why wouldn't we say that the plain text does not suggest that we're talking about any facial policy, but specifically instead, Special Order 20?
Just to clarify, Your Honor, the permanent injunction prohibits enforcement of the facial hair provisions of Special Order 20. And if you do a side-by-side comparison of Special Order 20 and what the department enforced, bulletin number 10, they're identical. The department took the precise facial hair language from Special Order 20 and put it in the policy that they enforce against plaintiffs. So it's a clear violation of the permanent injunction because they enforced a precise provision that they were enjoined from enforcing.
Well, those two, Special Order and the Bulletin 10, had different purposes, right? I mean, Special Order 20 was referring to fumes and vapors and sprays, et cetera, versus Bulletin 10 was in response to COVID, as you indicated.
Yes, the department's proffered justifications for the two different policies differ, but that's immaterial on the question of contempt because the language of the permanent injunction is clear. The permanent injunction does not distinguish purposes. It does not say the department is prohibited from enforcing Special Order 20 insofar as it offers a safety justification. It speaks categorically. It enjoins the department from enforcing the facial hair provisions that I just discussed, full stop.
Do you think those facial hair provisions also include the penalty, right? So the penalty is different in the 2020 policy, right? It's not termination, it's a different consequence of failing to shave. And it's not a requirement to shave. There is, you're moved into an administrative position, which is a burden, but not the same type of burden as termination from your job.
Two-part answer to your question, Your Honor. First, our position is that the enforcement mechanisms or penalty mechanisms are not part of the facial hair provisions of the order. So when the permanent injunction enjoins the department from enforcing the facial hair provisions, penalty provisions are separate and apart from that. Secondly,
Are the penalty provisions relevant insofar as the injunction refers back to the memorandum order finding a RFRA violation? And part of the analysis of the district court there was that the penalties were not the least restrictive means of addressing their safety concerns. And so when there's a different penalty in 2020, arguably the least restrictive means analysis would possibly be different.
so this was going to be my second point to Your Honor, in that there really isn't a separate penalty in 2020 versus 2007. In 2007, what had happened during the pendency of that litigation is that plaintiffs had been put on administrative duty. And if Your Honor reads the permanent injunction language, it specifically orders the department to return them from administrative duty to field duty, which is exactly what happened in 2020. Plaintiffs were placed on administrative duty for a year and a half. So the idea that there are separate penalties doesn't withstand scrutiny. The exact same thing happened. In 2007, they failed to comply with the facial hair order, so they were put on administrative duty. 2020, same thing. Failed to comply with bullet number 10 due to their faiths, placed on administrative duty. It's part and parcel.
Is there any policy that would comply for facial hair? If the department wanted to exercise facial hair, do you think any facial hair policy would be in violation of the injunction?
The department in theory is not prohibited from doing anything it wants with respect to facial hair, so long as it petitions the district court for a modification of the permanent injunction and goes through the analysis that RFRA requires. That is a least restrictive means analysis. The department has to make its case to the district court that its proffered policy is the least restrictive means of fulfilling a compelling interest. And that's what the department did not do in this instance.
Even in light of COVID, you would say?
Even in light of COVID. COVID did not suspend individuals' rights under RFRA or any other law. The Federal Rule of Civil Procedure 60B provided the department with an opportunity, and they chose not to avail themselves of that opportunity, so they should be held in contempt. Judge Lee.
Mr. Roth, can we just talk about what the district court in fact did in this case? So the district court says plaintiffs may well have proven that the department violated a clear and unambiguous order by issuing and enforcing a policy. Is that a finding that there was a violation of the injunction? It seems to be maybe that the district court is assuming there was a violation and then applying some sort of discretion to not find a violation.
I think the best reading of that language is that he found that there was a violation, but I understand that reasonable minds can differ on that point.
So if he say he did not find a violation, wouldn't the appropriate course for this court to be to remand for the district court to make such a finding? It seems that we have a number of cases suggesting that in the context of civil contempt, where there are private rights at stake, a court doesn't have discretion not to make a finding of whether there was a violation of the injunction. And so if such a finding wasn't made, wouldn't the proper course be to remand?
Absolutely. Yeah, Your Honor could absolutely remand to Judge Leon to make that finding. Alternatively, this court, if it wanted to, could make such a finding. As I've just explained, it's clear that there was a violation here, but a remand would absolutely be a proper course.
And if we were to remand, these arguments, does a district court have discretion to excuse the violation of, if a party is found in contempt?
If the court has found a violation and in contempt, there is ample discretion. As we mentioned in our brief, there are several defenses to contempt in this circuit: substantial compliance and impossibility, neither of which apply, but they are viable defenses. But also there's significant discretion at the damages phase. The cases are clear that much of the discretion that a district court judge has actually occurs at the phase after contempt has been found, and the question is quantifying damages that are owed to the injured parties. And
Well,
there's
let me make sure I'm understanding what you're saying. I went through the cases to try and make sure I had a grasp of what we've held. I don't see any cases that say a district court has discretion in the sense that the district court says the action taken in violation of the injunction was reasonable, and therefore I need not worry myself. That I don't see that as an exception. If there's a violation of the injunction, my understanding is the fact that the violator acted reasonably is not a defense in the law. If there's an inability or an ambiguity in the original injunction, those are all reasonable defenses. But then there would be no violation because of those. But I don't see anything in the case law that says if the violator acted reasonably, that's defense.
That's absolutely right. Good faith is not a defense. This whole court has squarely held that in Food Lion. Acting reasonably is not a defense. Those are not categorical defenses to contempt that have been recognized in this circuit, and that is no excuse. You see, I've gone into my rebuttal time, so I'm happy to continue to answer any of those questions.
Did the plaintiffs here separately bring a new RFRA claim against the actions taken in 2020?
In terms of a new lawsuit, no, they did not. They rested on the permanent injunction and did not bring a new original action.
Any further questions? Okay, we'll give you some time.
Good morning, Your Honors, and may it please the Court. I'm Dia Rashinario, and I'm here on behalf of the District of Columbia. In the March of 2020, the District and the DC Fire and Emergency Medical Services Department faced an unprecedented and imminent threat caused by the novel coronavirus that was rapidly spreading throughout the district. At the time, little was known about the virus. There was no cure, no effective treatment, certainly no vaccine. About 1% of the people who were infected died, with case fatality rates that were much higher for vulnerable populations. But what was known at the time.
So why did the district not go back for a modification of the injunction?
Right.
I mean, these are, arguably important interests that have been recognized by various courts. Perhaps they could have had a modification to the injunction. Why not go back to the court for such a
Yes, Your Honor.
modification?
Hindsight is a 2020, and we certainly think, looking back now from today's position, that would have been a more prudent and safer course of action. But there were two reasons for this. One was just the context of what was happening, how quickly the situation was changing, how unprecedented it was, the extraordinary circumstances. And the department was trying to figure out what was the best way to address this issue, what supplies it had, what methods would adequately protect its firefighters.
So even, we have many cases saying that in order to find contempt, a court doesn't have to conclude that the party being held in contempt acted in bad faith.
Yes.
So these arguments all seem to be about the good faith of the government.
Well, it did have a belief that the 2007 injunction did not apply to these extraordinary circumstances. And that's because even though the injunction might be superficially clear if read in isolation of the context of the case, the claims raised, the evidence presented, the memorandum opinion, if you look at that context, you see that that injunction was addressing a very specific situation. And that was firefighters involved in remedying hazardous conditions, fogs, gases, things like that. But it didn't contemplate, the parties didn't contemplate, and the district court didn't contemplate some sort of infectious disease that would spread rapidly, that would place almost any medical professional, such as the plaintiffs, who regularly dealt with patients in the course of their work, at risk in all of their interactions in the field. And so the injunction didn't contemplate the specific circumstances of this case. And courts, have said that when we look at clarity, we're not looking in some sort of general sense about whether the order is clear. We look at whether it's clearly prohibited the specific conduct. So the district.
I mean, there's an absolute clear violation. I understand the bind that the city was in. The simple answer is the one that's been raised. You go back to the court. That's really not hard or tricky or onerous. You go back to the court. Circumstances have changed. We want to modify the injunction. But you're not really suggesting, I don't see this in the law. And if there is a case that says it, I'd like to know it. You must show, there must be a showing of bad faith.
No, Your Honor, we're not.
I don't see that in the law, nor did I see anything about reasonableness or good faith being a defense. That's not what I understand. And I went through this because it's a situation where the city has a compelling concern, totally legitimate, I understand, but the law is not really sympathetic here. The law is you violate, and it's a clear violation here. The district court's not saying otherwise. District court's not saying this wasn't real. This is an absolute clear violation. It's the same provision that was in effect initially that's been violated subsequently. And so the answer normally is you go back to the court. You say we need a modification because we didn't anticipate this particular circumstance, even though we know there's a facial violation. What about, you've got laches, you've got acquiescence, you've got substantial compliance arguments that can be made on remand, right?
So, Your Honor, we disagree that this was a clear violation. And that's because we believe that you have to
What
look
was
at,
unclear?
because you have to look at it in the context. So for example, in the Washington-Baltimore Newspaper Guild case that this court
Now
decided.
tell me why in this case it was not clear. I
Because
don't
that,
need another context for you to tell me, looking at what was prohibited initially and then what happened subsequently, whether what happened subsequently violated what was prohibited initially. And to me, that looks as clear as anything I've seen recently.
Your Honor, and this is because the initial context involved different types of harms. And at the time in the memorandum of opinion, the district court had specifically contemplated looking at the plaintiff's ability to safely wear masks because of their facial hair in determining their assignments. And now is that, that might be a least restrictive means of accommodating them by moving them to a different position. And so given that broader context, the types of claims that were dealt with in that case, the district reasonably believed that that injunction did not apply. But I want to make another
The
point.
district was enjoined from enforcing these facial hair provisions, which are basically identical in the 2020 provision. So I don't understand what context.
Yeah, I don't understand.
I don't understand what context prevents this from being a clear violation of the injunction.
You're saying it's sad. That's a different argument, though. It is absolutely clear. It really is not a compelling argument to say that this isn't a clear violation. How we address this, the easy way to address it is you go back to the court.
And
That's your burden. That's what you should have done, not you personally.
no, I understand, Your Honor. And again, we do think that in hindsight, that would have been the more prudent course of action. I do want to address one point, though, which is that the plaintiffs were reassigned to their non-field operations right in the middle of March. So March 15th, 16th, and 17th. 2 days later, on March 19th, the district's counsel and plaintiff's counsel had a phone call where the district explained that it had reassigned the plaintiffs and explained the reasons for doing so. And then they sent a letter the very next day memorializing that conversation. And then they've never heard anything from the plaintiffs again about their objection.
The laches acquiescence or.
Of course, John, but if you're asking, why did the district?
But there's no findings on that. And that may be, those may be perfectly viable arguments, but they haven't been raised or addressed.
You're right.
We were just-
I mean,
we
they've
were
been raised. They
asking
haven't
about
been,
is how
they
can
haven't
you-
been.
All we were
That's right.
asking you about is how can you possibly say there's some kind of context which suggests this isn't this isn't a clear violation. It was absolutely a clear violation.
And just, so, I'm sorry, Your Honor, I'm just providing an explanation for why the district didn't seek to modify the injunction. And that's because they had this
I know, I
conversation and they
understand.
hadn't heard
I hear what
anything.
you're saying, and we're over that, but now you
Yes.
started talking about potential laches and acquiescence, and those are things that maybe the district court would have to consider, because it hasn't been considered yet.
But just taking a step back to context. So in the Washington-Baltimore Newspaper Guild case, that case involved an order that ordered the employer to arbitrate all grievances. That was the text of the order. But the employer didn't arbitrate certain grievances, holding the position that that order actually, read in context of the litigation, applied only to the type of employer discharges that had been at issue before the court. And when the civil contempt question was brought up, the district court agreed and this court affirmed, saying, you know, it's far more reasonable to conclude that that previous order only covered the grievances of the same character that were factually before the court at the
Not what
time.
the court here found.
Sorry?
That's not what the district court here said.
The district court here didn't make a determination on whether the injunction was clear and unambiguous in terms of its application to the specific context.
Well, but I mean, the case you just cited is not this case. There isn't a finding where the district court, who issued the injunction in the first place, said, no, we all understood it didn't go that far. That's not this case. So facially, what we're looking at is a case that is dead on point. You had an injunction that covered X, and then you had a violation of X, and now what do we do is the question.
And we think that that this court can decide the question of what the previous injunction covered de novo.
We would do it on
But if
our own motion?
If it's a question of law about what the previous injunction covered, if it's a question of the
That
application of that
surely
law.
would
to
be
the
something, if
context.
that's a viable issue, that surely be something that a district court should decide in the first instance, especially because the district court issued the injunction.
But we would not oppose a remand on that issue if the court decides that the district court should consider in the first instance.
No, you can, but it's not a reasonable.
But I did want to move briefly to the discretion aspect of this case. So this is the Seventh Circuit in some of their cases, so that is where the reasonably diligent and energetic standards comes from. And I agree with the court that there is some overlap between this first question of whether it's an order is ambiguous and the question of whether a contempt citation can be enforced when there is a reasonable belief about what that order covered. So I want to just draw the court's attention to Haggerty, where the Supreme Court specifically adopted an objective standard and said that if there is a reasonable interpretation of the order or of the law, and the party that is being sought to be kept in contempt of that order, acts because of that reasonable interpretation, you cannot have sanctions, or you cannot find them in civil contempt.
Is that a defense to contempt, or is that really about the inquiry, the original inquiry about whether there was, whether the injunction was clear and unambiguous and the violation was proved by clear and convincing evidence?
I think they overlap, Your Honor, because I feel like you could have an order where on its face, if you're not looking at the broader context, might appear to be clear and ambiguous, but where a party still has a reasonable interpretation of the order or the statute at issue.
So the court has to make that first determination about whether the injunction is clear and unambiguous and whether there's been a clear violation.
The violation, yeah.
Yes, Your Honor. All right.
Which seems like a good issue on remand.
Thank you, Your Honor.
No.
There are no further questions?
Just very briefly, Your Honors, a couple of points. First, to start off with the question of petitioning modification of the permanent injunction, I just wanted to emphasize the point that even in light of the pandemic, which was a sudden eventuality, the department chose not to go back to the district court at any point subsequent to March 2020. Even if Your Honors would want to say that March was a particularly tumultuous time, April 2020, May, June, July, and so on, they did not attempt to to modify the permanent injunction in district court. Complete lack of diligence on their part. Secondly, I would like to,
Cut him a little break. None of us knew what we were doing during the pandemic.
no, that's absolutely correct, Your Honor, but the courts were still operating and there
Well,
was.
That's what you normally would expect, but it was a pretty chaotic time. They
Yes,
may not have even remembered it.
And you didn't pursue it as a merits issue? The RIFRA claim?
Right, not as a standalone lawsuit. Correct. Secondly, on the point of context and injunctions, it just bears emphasizing that in their briefs to the district court, the department emphasized that an injunction has to be understood based on the four corners of the injunction, of the court's order, which is exactly the standard that plaintiffs have asked this court and the district court to apply. Looking at the permanent injunction on the four corners of the language, the violation is clear. For the department now to argue, all of a sudden context is important. First of all, there's no case law to support the theory that that's how you interpret an injunction. But secondly, that's contrary to the position that they took in the district court and therefore waived and inappropriate at this stage. And finally, on the point of acquiescence and latches, that can be decided on remand. Plaintiffs objected in the first instance immediately when they were removed from field duty, so that defense has no merit either.
But in light of what you stated, that if this were to be a remand with respect to question one, the district court should also look at what the department's defenses were to all of this as well.
Yes, that would be appropriate. The department has raised defenses in the district court, which are still pending in the district court, which could be considered on remand for an analysis of damages.
Thank you. Thank you. The case is submitted.
I'll report that down to parents until Tuesday, the 31st at 9:30 a.m.